We'll probably be one of the few. I'd like to think that I testified before this committee from a unique perspective, in that I am immersed in weekly maintenance of workers' legitimate grievances through our worker advocacy. In particular, our Stop Wage Theft campaign, our project, as we're able to provide DC workers with sound worker advocacy provided at no cost, thus we have no financial incentive. We educate and guide workers, distinguishing the wrong from the illegal. Now, our chief concern, in conjunction with our Stop Wage Theft project, is with the Department of Employment Services, Office of Labor Law and Employment. OLLI, or Office of Wage and Hour, whichever it is this week, is charged with the responsibility of investigation, determination, and enforcement of wage theft and other employment law violations. We've not experienced much improvement once an employee files a complaint with the Office of Wage and Hour. The law states that a determination shall be issued in 60 days, and I'll start there. My testimony today, not far removed, is pretty much in hopes that his firing, his wrongful termination, would be met with enforcement, and that not only would his job be preserved, but the wages that he lost. And unfortunately, that worker is no longer a D.C. resident. But, you know, they say he was low wage anyway. How valuable was he? I beg to differ. Several workers who've been victims of wage theft have asked for warranted accompaniment through the DOES enforcement process. As an advocate for my clients, I've been stifled in getting responses from DOES. What am I talking about? Glad you asked. Non-answered calls, failure to call back. I mean, I've recorded some of the messages I left, and respect for the complainant's wishes to have an advocate present. Since 2016, we've seen dismal results and observed the agency's operation. Their operation lacks rhyme or reason. I've worked with two other organizations before continuing my work with Sincere 7. And what we found is retaliation complaints often end up with the option to file with the Office of Administrative Hearings. What's the problem with that, you may ask? Glad you asked. And the answer to that is they start the process all over again. I have an ongoing list, like the push-button circle of hell when you call DOES. Non-compliance with the 60-day determination, of course. Retaliation claims see no action. So very simply, Sincere 7, in conjunction with our partners of Just Pay Coalition, we recommend default judgments when the employer elects to ignore DOES. Penalties be enacted, and a timeline of 48 hours for a response. Only sound management can remedy these failures of the agency. These issues aren't new nor novel, and thus we can change these problems if we change the head. You know, if you change the head, it can cure the illness of the body. So because DOES looks pretty much as it did in the previous reign, Sincere 7 opposes the confirmation of Dr. Morris Hughes. And Councilmember and those on your committee, thank you for allowing me this opportunity to testify.
Thank you, Mr. Redd. Mr. Session, welcome again.
Thank you. Good afternoon, Councilmember Silverman. I'm Warner Sessions.
What are the three big things to win you over?
Sure. I'm not a big fan of fairy tales, but to answer your question directly, one, when employers ignore DOES, and we've had this happen with some regularity, that a default judgment is issued in accordance to the Wage Theft, bless you, in accordance to the Wage Theft Prevention Act. That's one thing in particular. DOES has the authority to do that. Two, enact penalties, monetary penalties, upon these bad actors in particular. And then I think as a part of oversight, the agency needs to be penalized when it does not enforce the law, when the agency is not championing for workers who have been offended, when you got workers who the employer is not making up for the difference between their tipped wages and the minimum wage, and retaliation takes place. That is a more commonplace occurrence than not, and DOES has to have some penalty for not enforcing the law. And the third thing is retaliation claims. When a person files a retaliation claim, it must be investigated within 48 hours. I mean, I'm a strong advocate for that. And then a decision needs to come back in 10 days. I've got a horror story out of this world, and it's unbelievable. And sadly enough, this organization employs over 500 folks in our city. Not all of them live in our city, but 500 folks, and a significant number of them experience overtime theft. And they're scared to say anything because the one person who came forward, who we championed for, got his head cut off. And so retaliation must be addressed at an aggressive level.
Okay, thank you. Mr. Pita, I want to thank you for coming forward. If you were to give Dr. Morrissey suggestions on SYEP, what would those be?
I think